Hey folks, welcome to today's episode of the Law of Self-Defense show. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Thank you so much. And today we are continuing with our reading of an excellent book, The Art of Cross-Examination by attorney Francis Wellman. Wellman was an attorney in New York City around the turn of the century, the prior century. This book was originally published in 1903. The particular physical version I have in my hands was printed in 1948. It was a gift to me when I graduated law school. So the book, the contents is a bit aged, but the art of cross-examination doesn't really change because it's a function of human nature and human character. That said, I do caution that given the book's 120 years old since it was first written, the manner of writing and the language can be a bit stilted at times. That's just what we're going to work with. So we're going to jump into chapter 6 of the book, The Sequence of Cross-Examination. But before we do that, a quick word from today's sponsor. If you've ever wondered what it would be like to have a lawyer-like understanding of the many high-profile trials and legal issues we cover, well, I've got exciting news. Our very own American Law courses offer a wide variety of law school level courses, including the foundational courses all lawyers take in their first year of law school at a fraction of the cost and time of law school and without the toxic political environment that so pervades law schools today. At American Law Courses, we simply teach traditional American law in the traditional American way to help Americans become the best informed, most capable citizens they can be. We have a broad curriculum of courses, including criminal law, criminal procedure, evidence, property, constitutional law, and more. All courses are taught on a semester basis, roughly one live-streamed class a week for 14 weeks with an optional final exam for certification at the end. Every class is taught by a genuine legal expert in the respective subject, and because the classes are live streamed, there's plenty of opportunity for real-time interaction and Q&A with the professor. If you can't make a particular class for some reason, no worries. Every class is also made available as a recorded playback, and you have access to that recording for a full year. We've technically just ended the pre-registration period for the spring 2023 semester, which starts the second week of January. But for those of you accessing these readings of The Art of Cross-Examination, we've decided to extend that period for a few more days. This matters because during pre-registration, you can save 50% on any and all American law courses. That's a savings of over $1,000 a course. So if you'd like to learn more, now would be the time to do so. Learn more about our American Law courses, access the syllabus for each course, view interviews with our professors, and much more by simply pointing your browser to AmericanLawCourses.com today. All right, folks, we're back. Let's get started now with Chapter 6 of The Art of Cross-Examination. The chapter is entitled The Sequence of Cross-Examination. Much depends upon the sequence in which one conducts the cross-examination of a dishonest witness. You should never hazard the important question until you have laid the foundation for it in such a way that, when confronted with the fact, the witness can neither deny nor explain it. One often sees the most damaging documentary evidence in the form of letters or affidavits fall absolutely flat as betrayers of falsehood merely because of the unskillful way in which they are handled. If you have in your possession a letter written by the witness in which he takes an opposite position on some part of the case to the one he has just sworn to, avoid the common error of showing the witness the letter for identification and then reading it to him with the inquiry, "What have you to say to that?" During the reading of his letter, the witness will be collecting his thoughts and getting ready his explanations in anticipation of the question that is to follow, and the effect of the damaging letter will be lost. The correct method of using such a letter is to lead the witness quietly into repeating the statements he has made in his direct testimony and which his letter contradicts. "I have you down as saying so-and-so. Will you please repeat it? I am apt to read my notes to the jury, and I want to be accurate." The witness will repeat his statement. Then write it down and read it off to him. "Is that correct? Is there any doubt about it?" For if you have any explanation or qualification to make, I think you owe it to us in justice to make it before I leave the subject. The witness has none. He has stated the fact. There is nothing to qualify. The jury rather likes his straightforwardness. Then let your whole manner toward him suddenly change and spring the letter upon him. Do you recognize your own handwriting, sir? Let me read you from your own letter in which you say, and then you cite the contradictory contents, and afterward, now what have you to say to that? You will make your point in such fashion that the jury will not readily forget it. It is usually expedient, when you have once made your point, to drop it and go to something else, lest the witness wriggle out of it. But when you have a witness under oath who is orally contradicting a statement he has previously made, when not under oath, but in his own handwriting, you then have him fast on the hook, and there is no danger of his getting away. Now is the time to press your advantage. Put his self-contradictions to him in as many forms as you can invent. Which statement is true? Had you forgotten this letter when you gave your testimony today? Did you tell your counsel about it? Were you intending to deceive him? What was your object in trying to mislead the jury? A London barrister who often saw Sir Charles Russell in action said, "Some men get in a bit of the nail, and there they leave it hanging loosely about until the judge or someone else pulls it out. But when Russell got in a bit of the nail, he never stopped until he drove it home. No man ever pulled that nail out again." It not infrequently happens that the plaintiff and defendant are themselves the only witnesses to some oral agreement which becomes the subject of their litigation. Such cases often afford the most striking opportunities for cross-examination, where the advocate is armed with letters written by the party examined. In a case of this kind that I conducted some years ago, the plaintiff swore that the defendant, the late James B. Hagan, owed him over $250,000 as the result of an oral agreement made between them in the presence of only one witness who was dead at the time of the trial. The first 2 hours of my cross-examination of the plaintiff were devoted to the effort to throw him off his guard. I exhibited to him, by my questions, an apparent want of appreciation of the case and of the surrounding circumstances, allowed him to score on me over and over again until he was in the best of humor and was evidently feeling very confident of himself, at least so far as any fear of me was concerned, but all the time he was making admissions and misleading statements of fact, and even absolute fabrications which I knew would eventually be his undoing. I passed them all by as if they had aroused no suspicions in my mind whatsoever, although I was in a state of intense, secret exultation. Finally, he became so absolutely certain of himself that I was able to encourage him to hand me out big chunks of perjured testimony, which I knew would fairly engulf him later on. I had about a dozen of the plaintiff's letters, which I was confident he had either forgotten having written or else felt assured were safe in a foreign country, and which I felt equally sure he would repudiate as forgeries if he recalled their contents or had the faintest idea that they were in my possession. And if he denied them, it would be difficult to prove their genuineness and consequently be impossible to use them. I had no admittedly genuine specimens of his handwriting. I was watching the clock all the time for the hour of adjournment, ever keeping the witness pleased and even smiling over the seeming weakness of my cross-examination. Just at 4 o'clock, the hour for adjournment, and as he began actually to feel that $250,000 already won and in his pocket, I handed up to him a bundle of his letters in a manner from which he might readily infer that they were of no consequence, or at least as if I had not had time to read them, and asked him if he would please identify his handwriting before the court adjourned. He started to read the first one. Had he done so, all would have been over, but I checked him by reminding that it was 4 o'clock and requesting him to please not delay the adjournment by reading the letters, as all I wanted to know was if they were in his handwriting. In a moment or two, he had identified them all, and the court adjourned. The following day, I cross-examined him throughout the entire day about these letters. They contradicted in 100 different ways the assertions he had made so glibly the afternoon before, and at the end of the court session, his lawyer, the late John B. Stanchfield, actually withdrew from the case and a verdict was directed against him by the court, although neither side had called any witnesses other than the plaintiff himself. It was one of those rare cases where the cross-examiner has the written proofs of a witness's perfidy, which become such deadly weapons in the hands of any experienced advocate. Sometimes, on the other hand, it is advisable to deal the witness a stinging blow with your first few questions. This, of course, assumes that you have the material with which to do it. The advantage of putting your best point forward at the very start is twofold. First, the jury have been listening to his direct testimony and have been forming their own impressions of him. And when you rise to cross-examine, they are keen for your first questions. If you land one in the first bout, it makes far more impression on the jury than if it comes later on when their attention has begun to lag, and when it might only appear as a chance shot. The second, and perhaps most important effect of scoring on the witness with the first group of questions is that it makes him afraid of you and less hostile in his subsequent answers, not knowing when you will trip him up again and give him another fall. This will often enable you to obtain from him truthful answers on subjects about which you are not prepared to contradict him. I have seen the most determined witness completely lose his presence of mind after 2 or 3 well-directed blows given at the very start of his cross-examination and become as docile in the examiner's hands as if he were his own witness. This is the time to lead the witness back to his original story and give him the opportunity to tone it down or retint it, as it were, possibly even to switch him over until he finds himself supporting your side of the controversy. This taming of a hostile witness and forcing him to tell the truth against his will is one of the triumphs of the cross-examiner's art. In a speech to the jury, Choate once said of such a witness, quote, "I brand him a vagabond and a villain. They brought him to curse, and behold, he has blessed us altogether." Close quote. Some witnesses, under the style of examination, lose their tempers completely, and if the examiner only keeps his own and puts his questions rapidly enough, he will be sure to lead the witness into such a web of contradictions as entirely to discredit him with any fair-minded jury. A witness, in anger, often forgets himself and speaks the truth. His passion benumbs his power to deceive. Still another sort of witness displays his temper on such occasions by becoming sullen. He begins by giving evasive answers and ends by refusing to answer at all. He might as well go a little further and admit his perjury at once, so far as the effect on the jury is concerned. When, however, you have not the material at hand with which to frighten the witness into correcting his perjured narrative, and yet you have concluded that a cross-examination is necessary, as a general rule, it is but a waste of time to put questions which will enable him to repeat his original testimony in the sequence in which he first gave it. You can accomplish nothing with him unless you abandon the train of ideas he followed in giving his main story. Select the weakest points of his testimony and the attendant circumstances he would be least likely to prepare for. Do not ask your questions in logical order, lest he invent conveniently as he goes along. But dodge him about in his story and pin him down to precise answers on all the accidental circumstances indirectly associated with his main narrative. As he begins to invent his answers, put your questions more rapidly, asking many unimportant ones to one important one, and all in the same voice. If he is not telling the truth and answering from memory and associated ideas rather than from imagination, he will never be able to invent his answers as quickly as you can frame your questions, and at the same time, correctly estimate the bearing his present answer may have upon those that have preceded it. If you have the requisite skill to pursue this method of questioning, you will be sure to land him in a maze of self-contradictions from which he will never be able to extricate himself. One of the most thankless, but at the same time effective, uses of the opportunity to cross-examine opposing witnesses, a method which requires the greatest self-restraint and patience, is to content oneself with an apparently trifling admission from one witness, perhaps a further admission from the following witness, and thus gradually collect material which, when pieced into a mosaic, as it were, in the summing up, will surprise even your own client and compel a verdict in his favor. I have often employed this method myself and have invariably had to meet, at first, the profound disappointment of my client, only to be congratulated by him at the finish of the case when he began to see the little bits of testimony gradually being fitted into one another in an unanswerable argument in his favor. A real estate broker was suing to recover his commission on an alleged contract for the sale of a piece of real estate. The plaintiff claimed that the conversation between the parties comprising the purchase and sale had taken place on the 28th of December, the previous year, at the very premises that were the subject of the sale. The janitress of the building took the witness stand and testified that on that day, the plaintiff broker, the defendant owner, and the proposed purchaser all appeared at the house at about noon. The owner directed her to show the proposed purchaser and the broker through the building. That gave her the opportunity to hear the conversation in question, but it took her away from her kitchen and therefore prevented her from preparing the noonday meal in time for her children, who were then about coming home from school. She remembered distinctly that when she came back from the trip through the building, her 2 boys were home from school and complained that from the delay they would be late in returning. She, however, hurried through the preparation, served them their meal, and got them off as soon as she could. Her elder son, a boy about 12 years of age and a fine-looking little chap, took the witness stand. He remembered the defendant and the plaintiff and the proposed purchaser being there. He recalled that his mother was delayed in coming down to serve them their meal, and he remembered that it got very late and that he was calling his mother's attention to the fact that he and his brother would be late at school. They ran all the way from home to the school, and when they got near the school, there was one of the monitors in front of the school ringing the bell, indicating that it was late. He rushed into his classroom just at the last moment and was not late, but he remembered later on that his brother was marked late for the afternoon session. The cross-examination was unimportant and trivial, practically a repetition of what he had said on direct. The younger brother was then called, and he corroborated his mother and his brother and added the fact that he did get in late and was marked late. His cross-examination was negligible. The plaintiff and the proposed purchaser were then recalled by counsel and asked how it was that they fixed the date on which these incidents had occurred. The plaintiff produced an entry in his diary and by other circumstances fixed the date with absolute certainty. It could not have been any other day. The proposed purchaser fixed it by entirely different circumstances, but he too was positive that it could not have been any other day. The elder of the 2 boys was then recalled to the witness box and asked whether he would mind explaining to the jury how it was that he went to school on the 28th of December when every public school in the city happened to be closed between the 25th of December and the 1st of January, both days inclusive. He looked all around the room in a most hopeless manner, said that he could not explain, and thus a perfect case was destroyed by an over-perfect story. Some witnesses, though unwilling to perjure themselves, are yet determined not to tell the whole truth if they can help it, owing to some personal interest in or relationship to the party on whose behalf they are called to testify. If you are instructed that such a witness, generally a woman, is in possession of the fact you want and can help you if she chooses, it is your task to draw it out of her. This requires much patience and ingenuity. If you put the direct question to her, at once you will probably receive a "don't remember" answer, or she may even indulge her conscience in a mental reservation and pretend a willingness but inability to answer. You must approach the subject by slow stages. Begin with matters remotely connected with the important fact you are aiming at. She will relate these, not perhaps realizing on the spur of the moment exactly where they will lead her. Having admitted that much, you can lead her nearer and nearer by successive approaches to the gist of the matter until you have her in such a dilemma that she must either tell you what she had intended to conceal or else openly commit perjury. When she leaves the witness chair, you can almost hear her whisper to her friends, "I never intended to tell it, but that man put me in such a position I simply had to tell or admit that I was lying." One very skillful method of handling a witness, particularly when he is not only intelligent but shifty, is not to disclose your trump card, if you have one, until you have so completely committed the witness to the details of his story as to make it impossible to offer any plausible explanation of the damaging document with which you intend to destroy him. In a recent case brought by the Standard Oil Company of New Jersey, in the name of the original assignee, against the Texas Company, which was tried in our state Supreme Court before Mr. Justice McAvoy, the issues, involving many millions of dollars, were decided in favor of the nominal plaintiff, George T. Rogers, largely because of an admission wrung from a co-defendant, Joseph H. Adams, while he was unaware of its importance. This vital admission enabled the plaintiff to demonstrate that a long-forgotten document, innocent enough in itself, which had been delivered to Rogers by Adams many years before to inform him what the invention was in which he was buying an interest, described the very same mechanical features that the Texas Company claimed belonged to it alone. The co-defendant Adams was an inventor of a valuable process for converting crude oil into gasoline, now in general use in the oil industry. Years before the suit, needing money for his early experiments, he transferred nearly half of his interest in the invention to Rogers for $5,000. At the time of the transfer in 1907, 15 years before the trial, Adams delivered to Rogers a sealed envelope supposed to contain a description of the invention, enjoining Rogers not to open the envelope until after his, Adams' death. These early experiments proved unsuccessful, but later ones, dealing with the same general subject, resulted in the issuance of valuable patents and the acquisition of the entire invention by the Texas Company in 1919, to the complete exclusion of Rogers. At the trial, the Texas Company claimed that the invention, as finally patented, was not the invention assigned in part to Rogers because, in the early experiments financed by Rogers, the inventor employed a vacuum feature, while in the valuable patented process, pressure was used and not vacuum. Whether Rogers, and through him the Standard Oil Company, had any interest in the pressure patents was the main issue involved. It appeared that Adams had also assigned an interest in the same invention to the firm of Carey and Robinson by a contract which was subsequently canceled. In this contract were references to a so-called caveat, which mentioned the use of pressure. The cross-examination of Adams by Herbert C. Smith had proceeded for nearly 3 days, committing the witness to a detailed narrative of circumstances, during which time there had been no mention by the examiner of the apparently forgotten sealed document of 1907 until at the very close, when it was too late even to attempt to explain it away with any hope of plausibility. Question: did you understand that Carey and Robinson, by their contract with you, were limited to the vacuum phase of your process? Answer: no. Question: did they have an interest in the pressure? Answer: they might have had an interest for a time while their contract was in force. The court: the same interest as in the vacuum process? Answer: they had an interest based upon the caveat, which was in existence at that time, then filed in the early part of 1907. Question: that caveat was in respect to your possible internal heat and pressure process. Answer: it did not state either one or the other, but it did mention both. Question: it was intended to refer to both processes? Answer: it was intended to refer to either one or the other. Question: did you intend it that way? Answer: I drew the caveat. I mentioned that either was useful, either vacuum or pressure. Question: then it was based on the caveat that you made up your mind that this contract gave Carey and Robinson an interest in the pressure process as well as the vacuum process? Answer: it covered both vacuum and pressure with relation to the use of the electric heater. The court: was the agreement, according to your understanding, giving them a right to the pressure process or an interest therein because of what was described by you in the caveat? Answer: that would apparently be so because that was the only thing. Question: I don't care about the because, yes or no. Answer: that would apparently be so. The agreement between Carey and Robinson was then produced. Question: do you want to read it? Answer: yes, sir. Yes, this is the agreement. The agreement was then marked in evidence, and attention was called to its reference to the caveat. Question: is this the caveat which has been handed to me by your counsel that is referred to? Answer: that is apparently a true copy of the caveat if it is acknowledged by counsel. Then some papers were produced, written by the witness and filed in the Patent Office, which claimed the use of pressure as far back as 1907, the date of Adams' contract with the plaintiff. Question: when you use the words in these papers, dating back to 1907, are you referring to that caveat of January 1907? Answer: presumably, since the caveat itself and the drawings attached were filed at that time. Question: I call your attention to the diagram which is attached to the caveat and ask you, referring to Defendant's Exhibit F, which is labeled internal heat and pressure, whether that is not the same machine. Answer: it is the same general type of heater, the two drawings being somewhat similar. Question: but they are shown in the caveat, being drawing B116? Answer: yes, they are substantially the same. Question: now, Mr. Adams, do you recollect that in your early negotiations with Mr. Rogers, you gave him some papers that you sealed? Answer: yes, I believe I did. Question: didn't you give him a copy of the caveat? Answer: I don't recollect at this time. Question: you have no recollection of what you gave him? Answer: I recollect I gave him some drawings and descriptions, but what they were, I can't remember at this time. Question: did not those drawings and descriptions refer to pressure as well as to vacuum? Answer: I could not say. Question: are you willing that the court should see what you gave him? Answer: I do not see why I should object. Question: is this the envelope that you gave him? Answer: it appears to be. Question: is that your handwriting? Answer: yes. Question: will you remove the contents and see if that is in your handwriting? Answer: yes, sir, that is the drawing that I made. Question: is not that the original drawing of the caveat? Answer: it appears to be a transfer from the original Patent Office drawing. Question: now look at the description that is contained in the envelope that you have just removed. Is not that the original form of the caveat in your own handwriting? Answer: this is my own handwriting. Question: and is that what you gave Mr. Rogers, that and the drawing, 15 years ago when the contract was made with him? Answer: if this is the paper and the drawing that were in that envelope before it was opened, then I would say that. The envelope has been handed to me cut open with those papers within it. Question: and if I assure you that it is? Answer: I do not doubt your statement. Question: I can assure you that it is, that it was delivered to Mr. Rogers' attorney intact, that the seal was broken by his attorneys, and that it is in the same condition now as when it was delivered. The court: who authorized the opening of it? Lawyer: the majesty of the law. The court: Standard Oil, you mean? Will you look at this end and see if it is the caveat, and also call your attention to the legend at the top in your own handwriting and ask you to read it? Answer, the witness reading: caveat, copy of original filed at Washington Patent Office, January 2nd, 1907. It was the successful use of this forgotten 15-year-old written document in Mr. Smith's possession which enabled him in a few well-directed blows to shatter the entire stronghold of the defense in a trial lasting many weeks and involving questions of ownership in an invention that had been variously valued between $10 and $40 million. An English lady once asked the Lord Chief Justice what was necessary in order to win a case in court. He replied, "First, you need a good case. Then you need good evidence. Then you need good witnesses. Then you need a good judge. Then you need a good jury. And then you need good luck." The celebrated case of Reich v. Cochran, which has been in the courts for 32 years and was only finally decided in favor of the defendant by the Court of Appeals a few months ago, affords a striking illustration not only of the uncertainty of litigation, but of this good luck, which is sometimes more important than skill on the part of the cross-examiner. There have been 3 trials of this case and a dozen or so more appeals to the higher courts. The litigation concerned the old Cambridge Hotel at 33rd Street and 5th Avenue, opposite the Waldorf Hotel. Reich had secured a long ground lease from the Astor estate and wanted to rebuild the property. Cochran had been advancing him money for that purpose until the advances had aggregated several $100,000. After numerous defaults on Reich's part, Cochran took over the lease and gave back to Reich a sublease for a term of years, with the rentals so arranged that he, Cochran, would just about get back his money at the termination of the lease. Reich defaulted in the payment of the rent and was dispossessed sometime in 1902. Thereupon ensued a stream of litigation, beginning with an action by Reich in which he claimed he was an illiterate Hungarian, unable to read or write English or any other language, that the assignment of the Astor lease to Cochran and the giving back of the sublease to him, Reich, were not absolute transfers, but were given as security for an usurious loan, and that they were fraudulent. The first trial was before Mr. Justice Geigerich, and the decision was in favor of Reich, whose long and intricate story of wrongdoing at the hands of Cochran was taken at its face value by the presiding judge, who denounced Cochran in unmeasured terms. The case was taken to the appellate division, where the judgment was reversed upon technical grounds, but the court again took occasion to excoriate Cochran in an opinion in which Reich's story was upheld. The next trial was before the late Justice Bischoff, and again lasted for 6 weeks. The plaintiff Reich had given his direct story and recited his wrongs during 3 or 4 days' session of the court, before being handed over for cross-examination to Mr. Samuel Untermeyer, representing Cochran's executors, Cochran having died. After 2 days' cross-examination, the presiding judge called Mr. Untermeyer to the bench and warned him to conclude his cross-examination, saying that it, in his judgment, had gone far enough, as Reich appeared to him to be telling the truth. Mr. Untermeyer persuaded the court to bear with him for another day, upon his agreement to finish the examination if by that time he had not succeeded in proving to the court that the witness was a keen, clever businessman and merely posing as ignorant and illiterate. Reich's entire story was predicated upon his claim of ignorance, illiteracy, and want of understanding of the dozen or more documents that had been signed by him. He had also charged not only the defendant, Cochran, but the defendant's lawyers, prominent members of the bar, with being parties to the conspiracy to defraud him of his rights. Just at the close of the 3rd day, it occurred to Mr. Untermeyer to make one last leap in the dark, and he turned sharply upon the witness with the question, "Were you not a rabbi in the old country?" To which the witness unguardedly replied, "I don't remember." Rabbis in the old country, as everybody knows, were men of deep learning, and from that time on, Mr. Untermeyer had very easy sailing in his cross-examination, which lasted for about 10 days, and which succeeded in completely demolishing the plaintiff's story. Mr. Untermeyer had no foundation for the question other than the general appearance of the man, which suggested that he might have been a rabbi at one time in his life, and if so, must, of necessity, be a highly educated man. Judge Bischoff, in deciding the case for Cochran, denounced Reich and repudiated his entire story, and the judge's findings went to the Court of Appeals, where the decision was unanimously affirmed. It is not an uncommon practice among the younger lawyers who have read of the triumphs of their more experienced seniors to try to imitate them in their own practice. This is praiseworthy enough, but the proper occasion is not always selected. The question, "Where were you on the 29th day of last October?" was put by one of these young advocates without the slightest motive on his part, but as a chance shot to see if he could develop something to his advantage. Embarrassment, if nothing else. Opposing counsel: "I object to the question as immaterial and as evidently intended to bring in some collateral matter that has nothing to do with the issue in this case." By the court: "How can I determine that until I hear the answer?" Cross-examining counsel: "Oh, very well. If my opponent wants to conceal the facts from the jury, I'm willing to withdraw the question." Witness to the court: "Your Honor, I'm perfectly willing to answer the question." The court: You see, gentlemen, the witness himself is willing to answer, so I presume all objections are withdrawn. Now, Mr. Witness, you may answer the question and tell the jury where you were on the 29th of last October. The witness, promptly, I don't remember where I was, Your Honor. In all your cross-examinations, never lose control of the witness. Confine his answers to the exact questions you ask. He will try to dodge direct answers, or if forced to answer directly, will attempt to add a qualification or an explanation which will rob his answer of the benefit it might otherwise be to you. And lastly, most important of all, let me repeat the injunction to be ever on the alert for a good place to stop. Nothing can be more important than to close your examination with a triumph. So many lawyers succeed in catching a witness in a serious contradiction, but not satisfied with this, go on asking questions and taper off their examination until the effect upon the jury of their former advantage is lost altogether. Stop with a victory is one of the maxims of cross-examination. If you have done nothing more than to expose an attempt to deceive on the part of the witness, you have gone a long way toward discrediting him with your jury. Jurymen are apt to regard a witness as a whole. Either they believe him or they do not. If they distrust him, they are likely to disregard his testimony altogether, although much of it may have been true. The fact that remains uppermost in their minds is that he attempted to deceive them, or that he left the witness stand with a lie upon his lips, or after he had displayed his ignorance to such an extent that the entire audience laughed at him. Thereafter, his evidence is dismissed from the case so far as they are concerned. Erskine once wasted a whole day in trying to expose to a jury the lack of mental balance of a witness, until a physician who was assisting him suggested that Erskine asked a witness whether he did not believe himself to be Jesus Christ. The question was put by Erskine very cautiously and with studied humility, accompanied by a request for forgiveness for the indecency of the question. The witness, who was at once taken unawares, amid breathless silence and with great solemnity exclaimed, "I am the Christ," which soon ended the case. And that's it, folks, for Chapter 6 of The Art of Cross-Examination, the sequence of cross-examination. We continue in the next Law of Self-Defense show and our reading of The Art of Cross-Examination with Chapter 7, Silent Cross-Examination, and I look forward to seeing a bunch of you there. Until then, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe. If you've ever wondered what it would be like to have a lawyer-like understanding of the many high-profile trials and legal issues we cover, well, I've got exciting news. Our very own American Law courses offer a wide variety of law school-level courses, including the foundational courses all lawyers take in their first year of law school at a fraction of the cost and time of law school and without the toxic political environment that so pervades law schools today. At American Law Courses, we simply teach traditional American law in the traditional American way to help Americans become the best informed, most capable citizens they can be. We have a broad curriculum of courses, including criminal law, criminal procedure, evidence, property, constitutional law, and more. All courses are taught on a semester basis, roughly one live-streamed class a week for 14 weeks with an optional final exam for certification at the end. Every class is taught by a genuine legal expert in the respective subject, and because the classes are live streamed, there's plenty of opportunity for real-time interaction and Q&A with the professor. If you can't make a particular class for some reason, no worries. Every class is also made available as a recorded playback, and you have access to that recording for a full year. We've technically just ended the pre-registration period for the spring 2023 semester, which starts the second week of January. But for those of you accessing these readings of The Art of Cross-Examination, we've decided to extend that period for a few more days. This matters because during pre-registration, you can save 50% on any and all American law courses. That's a savings of over $1,000 a course. So if you'd like to learn more, now would be the time to do so. Learn more about our American Law courses, access the syllabus for each course, view interviews with our professors, and much more by simply pointing your browser to AmericanLawCourses.com today.